So good afternoon. Welcome to the first junior academic session of CPDP 2019. My name is Ignacio Sanchez. I will just briefly introduce myself and the panel. My name is Ignacio Sanchez. I work for the Joint Research Center of the European Commission, so JRC. JRC is a Directorate General of the European Commission. It is essentially the in-house science and knowledge service of the Commission, the scientific side, if you will. I'm coming from a unit that is the Cyber and Digital Citizen Security Unit, and we carry out research on cybersecurity, privacy, and data protection. And in this context, we are supporting 6 of the students that are presenting their papers in CPDP this year, of the junior students. So I will be chairing this session. The session will last for 1 hour and 15 minutes. We have 3 speakers that will look at the General Data Protection Regulation, different aspects of the General Data Protection Regulation from different perspectives. There will be a discussion about and a presentation about artificial intelligence and General Data Protection Regulation, in particular the aspects that relate to the right of explainability and all the ramifications. There will be also another presentation that will be related to children's rights, online and General Data Protection Regulation, and yet another one about public registers. And well, basically the idea is that every speaker will have 20 minutes to present their research, and every presentation will be followed by questions and answers. And at the end of the session, if there is still time, we can have another round of questions and answers that could be addressed to any of the speakers. So our first speaker is Gianclaudio Malgieri. He is part of the multidisciplinary research group on law, science, technology, and societal studies of the VUB University, and he will be presenting his research about the right to explanation and algorithm legibility in the EU member states legislations. So, Gianclaudio, the floor is yours.
Okay, so thank you very much, Ignacio. I'm very happy for presenting here. First time I presented was CPDP 2016. So after 3 years, I'm happy to change subject, but to have this opportunity. I'm presenting about automated decision making in the EU member states, and it's like a couple of days that this, I know, maybe more, but for me, that this topic has become ADM, or at least is becoming to be called with this acronym ADM in the European Union member states. I've received very interesting feedback from the reviewers, so that's why I've reworked on the paper, and now it's on SSRN, the updated version. I just updated it yesterday. And I also changed a bit the title. It's automated decision making in the European Union member states, not just explanation, but mainly other safeguards that Article 22 seems to suggest. So, and it also builds on a previous a paper that I had in the end of 2017 with an Italian professor, and it was like a reply to the very famous paper on why a right to explanation does not exist. And we replied on the same journal saying, actually, why a right to legibility exists in the GDPR. And building on that idea of legibility, the idea was to look into European Union member states implementation law, so GDPR implementation laws, and see what, can we find if there is something more explicit about explanation, or if we have some opportunities, some examples that we could export in other systems or as best practices for companies, etc. So this is Article 22 of the GDPR. Probably most of you know it. I'm particularly, I mean, three things in this article will be important for the analysis of member states' implementation. The first one is the definition of automated decision making. Just some decisions are defined there. And which ones? So the scope of automated decision making regulation is incredibly diverse, different in member states. So even though Article 22.1 is quite clear, we will see that there will be different interpretations and different declinations. And this is a legal issue. Can member states' law have differentiate from the GDPR? We will see a bit the European Union law allowing this difficult implementation issue. Then the other point that we really need to know is that paragraph 2 allows exemption of automated decision making, and letter B is the one that we are analyzing now. So member states' law can authorize some automated decision making in some cases with suitable safeguards. So here are the three things that we will analyze: the scope, the cases in which member states' law decided to implement it. So say general exemption, sectorial exemption, future-oriented approach, and then the suitable measures, which was actually the title. Of course, we don't have just Article 22, we have also recital. And I forgot to mention paragraph 3, which is about examples of safeguards. And we have the most famous examples, so right to obtain human intervention, so the human in the loop, very famous. Then we have the right to express one's point of view and to contest a decision. I think that we can agree that these three safeguards are very much interrelated, because if I have a right to contest, probably I have a right to express my view, and at the same time I have a right to have a human in the loop. It's not so natural, but I think that a good implementation of it would be a coordination of these three safeguards, maybe with something more, which is in recital 71. So right to challenge, which is actually an overlap with right to contest. Right to be informed, and it comes also from Article 15, letter H, so meaningful information about logics and consequence and advisable effect of automated decisions, and right to explanation, and a great debate around that. But Article 29 Working Party Opinions also stressed that another safeguard that should be used is, for example, impact assessment and finding mathematical or organizational techniques for dealing with this. Now, let's see how member states have developed, have implemented this Article 22 letter, paragraph 2 letter B. So, first of all, these are the only 9 member states that that implemented this provision. I presented just the first description of these cases in Amsterdam Privacy Conference in October. Now, I mean, at that time, I had just the time to read the laws, because as you can imagine, these laws were approved between January and December 2018, and some member states have not yet implemented it. So this was like a great job to do, because actually I had to analyze all the 27 member states' implementation law with clear problems in language transposition, so like linguistic problems. And I profited from some friends from different countries. So, for example, for Hungary or Lithuania, etc., or Greece, I needed their help, because otherwise it would have been quite impossible to do this work. And these are the only member states' law who have some reference to it. A disclaimer is that also Spain has some reference to it, but not implementing Article 22. Just saying that right to object, you probably know that right to object is based on the particular condition of the data subject. And they say, implementing this right to object, that one particular condition is that I am subject to automated decisions. So but it's just an implementation of right to object, not right not to be subject to automated decision under Article 22. I see that the line is very blurred, but I wanted to take just member states who really built on Article 22. So we have Ireland and United Kingdom. It was still in the European Union, and it is still today. France, Netherlands, Belgium, Netherlands, Germany. We had also Austria, Slovenia, and Hungary. These were the only member states who had in their laws some reference to Article 22. Very different approaches. So, the three lines that I'm following for this analysis are what, when, and how, not why, because why, I leave to you the answer. Why are we protecting individuals from automated decisions is beyond the scope of my paper, and I leave this discussion to philosophers and to sociologists, etc. But what I mean, which is the scope of automated decision-making regulation. So which automated decisions trigger the attention of the legislator or the national legislator. Then which cases are exempted from automated decision-making prohibition? For example, if there are specific exemptions or general or future-oriented. How, which safeguards are provided? There are different approaches for any of these. For the scope, we have a neutral approach, which is taken by some countries, in particular from Germany, from United Kingdom. We have also, what is particular is also the negative approach. So even the definition of automated decision making is even closer, is even narrower than the one proposed in the Article 22. This is the case of Slovenia. We will analyze this case in detail. And then the positive approach. So countries in which the definition of automated decisions was bigger. So for example, they don't say legal or similarly significant effect, they just say adverse effects. So this is the positive approach, positive like broadening approach. Then I forgot to say that just yesterday was launched from Algorithm Watch was launched this study on automated decision making in European Union member states, and it was nice because I had no opportunity to read it because it was launched yesterday, but it analyzes member states in the terms not of law but of practices. So they say in this country we have these softwares that do automated decisions, see problems, etc. So this is a different complementary study, but we need to coordinate a bit. So which cases are exempted from ADM prohibition? So if in some cases there is a general exemption. This is the case of France and a bit France because it's also sectorial, and United Kingdom. Then future-oriented exemption. For future-oriented, I mean in the future there will be some law that will allow some cases. Now the law is just saying that these laws will have to provide some safeguards, and they tend to describe these safeguards. It will be clearer in a moment. And then sectorial exemption. The biggest sectorial exemption is Germany, because in Germany just insurance sector is regulated under automated decision making. And then we have also France, France and the Netherlands, they make distinction between public bodies and private bodies. So public administration decisions and private controllers decisions. And I think it's something that should be analyzed in the future. And then the last point, which safeguards are provided, there is a neutral approach. So some member states just copy and paste what is Article 22, paragraph 3. So right to contest, right to human intervention, etc. Then there is the procedural approach. So for example, they, and this is the case of United Kingdom and also Ireland, they say, we will analyze it in a moment, but actually the procedural approach is based on notice, contestation, and then explanation of how your contestation was taken in consideration. So this is a form of accountability, and it's a form of maybe ex post explanation. I explain you how the human intervened in this decision. So I think it's a very practical approach that we always underestimate. We are never talking about right to contestation. We never, right to challenge is something that is there, and we always focus on right to explanation, but maybe I think that this is the key for opening the discussion on right to explanation and changing it a bit and making it a bit more effective. Legibility approach. So in some countries, France and also in Hungary, they have these explanations of methods and criteria used. So these are the most interesting cases in which actually we can see this right explanation in the legal test. And then algorithmic impact assessment, which is already a bit in the GDPR, because actually the data protection impact assessment, maybe you know, under Article 35, we need to perform this data protection impact assessment in cases, for example, monitoring individuals using, and any case in which there is a risk for rights and freedoms. So I think this is a case, but then impact assessment in Slovenia is put exactly in Article 22 implementation provision. So just a step behind on what is regulated. These are the countries in which we have like a neutral approach. They just copy and paste either Article 22, or they say that they just copy and paste what is there. So legal effects or similarly significant effects. Okay. So these are the countries that actually either they take, they just mention Article 22, or they reproduce what is inside. I think that UK and Ireland had an easy play, because actually they use English. So for us to compare this legal text, it's easier to see how similar they are. Sometimes when I translate it from some other languages, I could see some differences, which actually probably are just translational issues. So this is a methodological issue that I need to be aware. So, and the Slovenian law is particular because the scope is bigger, is narrower than Article 22, because they say decisions based exclusively on automated processing of personal data that have negative legal consequences or likely to affect them to a greater extent. Actually, Article 22 does not mention negative. It just say similarly significantly affect. So you see that here the national legislator is taking a position and says, I want to regulate just negative cases, not positive ones. The Article 29 Working Party Guidelines actually said no, even positive decisions are similarly significant. So why the Slovenian legislator choose to do that? Probably they are free. I mean, they are free to implement this way because Article 22 always applies, and this is something more. But it would be nice to see the discussions, and they still didn't. And this is the positive approach. So enlarging the scope. The French law says legal effect or significantly affect. So there is no reference to similarly significant effects here. Hungarian law and Austrian law and Belgian law have something similar. So they consider automated decisions who are just either prejudicial or detrimental, etc., to data subjects. So you see, there's not the constraint of legal or similarly significant, but any prejudicial or detrimental effect. So what is missing here is this similarly. So significant effect similar to legal one. No, any prejudicial. So here it's bigger. And so here is the open issue. Can member states regulate, can member states broaden the scope of Article 22? So can I, for example, I don't know, France, say that my citizens should have a higher standard of protection for automated decision making? In principle, if we look at the Edinburgh European Council resolution, it's actually 1992. Sorry, they were saying that if member states respect the objective of the law of European Union legislation, they can set higher standards of rights. But they need to respect objectives of European Union law, and this is a regulation which has a higher level of harmonization. It's not a minimum harmonization. So the case here was, let's look at the objectives of the GDPR to see if it's possible to enlarge the scope of Article 22, even respecting the objectives of the law. But the objectives of the GDPR are not only enhancing the right to data protection of natural person, which is actually clear in Article 1, paragraph 1, but it's also entering free flow of data in the European Union market without unjustified obstacles. So, and this is very clear in Recital 13, for example. They say you cannot put more obstacles on individuals. You cannot put more obstacles to the free flow of data. So in this case, if member states are broadening the scope of Article 22, and so if they say that automated decision making is prohibited not only if it has legal or similarly significant effect, but even if they just have some prejudicial effect, as we were saying here, so prejudicial or detrimental, actually we really acknowledge, we really see that here this objective is violated because they are creating more obstacles. They are creating more restraints to that. So it's open to discussion, I think, but at this moment I think this is something that European Court in Luxembourg will need to analyze, and I think that companies will for sure say that, I mean, it's a violation of the GDPR. Then when is permitted? General exemption, future oriented, or sectorial exemption. The general exemption is in UK and France, where a controller takes a qualifying decision, so a decision based on Article 22, paragraph 1, the controller must respect some safeguard. So now the law in the United Kingdom is permitting automated decisions in any case, just if they respect the law. So it's a general exemption. Similar in France, but they have differences that we will see in a moment between public and private data controllers. Then the future-oriented approach. These countries, I will not read it, you can read it, I mean it's quite obvious. They just permit automated decisions if they will be regulated by future laws. It's a bit strange way of dealing with the problem, because now I'm wondering, so can I do automated decisions under, for example, in Slovenia, Ireland, etc., if there are no sectoral law that permit it just under Article 22? Yes, but should I apply the safeguards described in these laws? Okay, I will run more. Then sectorial exemptions. And I just want to focus on Germany because it's the most interesting one. Right, according to Article 22.1, shall not apply if the decision is made in the context of providing services pursuant to an insurance contract. Why? Because, I mean, service portion to an insurance contract means that maybe the beneficiary of the insurance service is not a contracting party. So this form of service provision could not be under Article 22, letter A, about contracts. No, sorry, it's letter C. Because you are not a contracting party, so Germany is creating a particular exemption for this. So it's quite interesting, what they are doing. In France, I don't have time to go in deep, but you see that for administrative decisions you have some more requirements than in, for example, private data controllers. So does not involve sensitive data, respects administrative procedures, etc. Why? Because in France we already had loi pour une république numérique, was 2016, so before the implementation of GDPR, and they already provided something on that. I will just close on this open issue and then just an overview of the safeguards. So, open issue, positive decision. In Germany, there is one provision saying, actually, that if the automated decision-making outcome is just to grant the right, to grant the request of the data subject, you can do it. So, positive decision that grant the request of the data subject. Is it respectful of GDPR? This is my question to you. Because Article 22, letter B, just says that member states can create new exemptions. It does not say that they can change the definition of Article 22, letter number 1. So, in practical term, similarly significant effect should include also positive decisions. For example, if the request that I make is very risky for me, and you are just granting it to me, it's an automated decision who is having like a significant effect for me, and you don't need to use any safeguard just because you're granting my request. So I mean, this is an open issue. And I close with this slide in which I just summarize which are the most interesting, the safeguards that are used in member states. So I've already talked about United Kingdom, the procedural approach, just the French one, which is like, and the Hungarian one, method and criteria used in decision making. Like so Slovenia, maybe if you have a question, impact assessment should be done for automated decisions. So you see these different paths here, legibility, procedural, and human rights impact assessment. I think that these are the three big ways in which we could regulate automated decision making. And if you have questions on that, I will reply, because I've finished my time minutes ago. Sorry.
Thank you very much, Gianclaudio. So we can now perhaps take some questions on this presentation. Yes, please.
Hi, my name is
Maybe this is a microphone for. Yeah, you can use this one.
Please use that microphone. Yes.
Hi, no, it's not functioning.
Yeah, it's working.
So my name is Domenico, University of Oslo.
No.
I have a question. Whether you studied practice, maybe some case law or any decisions of local authorities, and what is your methodological basis of your research, and how you enforce the validity of your results?
Yeah.
Thank you.
Yeah, thank you. So actually, I could not analyze all DPA's decisions, but thank you for your question, because it allows me to talk about just the two cases in which I could analyze DPAs, which is Germany and Austria. There were, in these cases, you see, these are very new legislation, so we don't have decisions that are already applying or implementing these GDPR implementation laws, so we cannot have something on that. But I sometimes used DPA's, data protection authorities' decisions that were building on the national data protection law before the GDPR, because sometimes it helped me to understand how was the approach of commentators and judicial authorities toward this. For example, in Germany, they had a wide approach, so they had a good regulation and self-regulation, for example, of insurance sector, and they were, precisely regulating that sector. So for me, it was important to know that. And in Austria, they had this also wide approach, for example, in the definition of cases, etc. And about methodology, so actually I used, as I was saying, it was difficult to use all member states' law and with all translational problem. So I first of all used this different helper who suggested me how and whether there was this regulation, this provision in their law, and then I use a literal comparison with the official translation in different languages of the GDPR to see how distant they were, and how, because I see that there might be a lot of issues in translating, for example, adversely affect. Okay, so that's why I said detrimental, etc. But in some cases, like in the Netherlands or in others, the translation was different from the GDPR text. So it was like a literal comparison between these ones. But I'm sure that more laws, more data protection authorities, etc., will clarify better how we should interpret this one.
Is there any other question?
Is it working? No, I'm
No, it's...
Ah, great. No. It's working.
I was just wondering, because you said about harmonization levels, in Article 22. So I was wondering whether you assess this from a broader EU law perspective.
Yeah.
So, the need to take into account case laws such as Maloney, which, deals more with the arrest warrant, that directive, but I think it would answer many of the questions that you have, because it still referred to constitutional norms.
Yeah.
So it might...
In particular, I found useful the discussion on gold plating and all that issue, because I did not I didn't go inside Maloney case, etc., because otherwise the paper would be huge, because it's 40 pages now. But I was looking at the decision, etc., and there is this big discussion on gold plating, which means member states create more safeguards for their individuals, and this is not allowed because it's higher harmonization level. So yeah, for sure, I will integrate with some European court cases. Yeah.
Okay, thank you very much.
Maybe there was another one, but we can keep for...
Yes. let's go for the next presentation. There will be still a few minutes left at the end, so you can still formulate questions to any of the speakers. So, Geert Lockhorst, I hope I pronounce it accepted.
Lockhorst.
Okay. He's coming from the University of Amsterdam, and he will be presenting his research on personal data and principles of proportionality in public registers.
All right. Thank you very much. Well, I had this whole introduction prepared about who I am, but thank you for doing that for me. So for the past period, I've been working on a research paper on something under supervision of Mireille van Eechoud. I think should mention where credit is due. Thank you very much for all the help in writing this paper. And it's about something which is actually a pretty common occurring practice, I think. It's about public registers which are held by the government. So to give a little bit more context, what you can think about is a country's company register, which keeps tab of all the different companies that are practicing in a certain country, or a publication of names of everyone in a certain regulated profession. So what you have, for example, in the Netherlands is you have a bar registration or a registration of lawyers, which on a website you can find all the lawyers that are active in the country. So the idea was to look at these public registers and in what sense the creation and the maintenance of these registers from a data protection perspective, to explore in what sense the legislator, when creating these registers and when deciding to maintain or adapt them, keeps in mind the different issues for data protection. That's really broad. I'll get back to the more sort of specific tests that have been applied here later on. Basically the test followed 3 steps. First, we looked at what kind of registers there actually are in the Netherlands. Second, we looked at what legal requirements apply, so we'll come back to that. And after that, we checked whether the Dutch legislator actually applied these data processing principles when deciding to create a register. So it's really from a high-level legislative process. We're looking at the legislative record to look at the assessment of proportionality in creating these lists which publish personal data on a pretty regular basis. So, yeah, as a first step, we had this general inquiry on what registers exist, and if you type into all the government databases and on Google register and list and data protection and list of names and data, you get about 300 or 400 results. So that was slimmed down to public registers which are actually intended to directly identify a natural person. So simply put, these are registered that put a name on the list that's available to the general public. Like I said before, the registration of lawyers, where you can go to a website and look up every lawyer that's active in the country. So we selected those types of registers because the idea was that those registers are most likely to be accompanied by some discussion of rights of privacy and data protection in the legislative record to the creation of these registers. So this also means that some other registers which are not really open to the public have not been taken into account. In a lot of these registers there could be privacy and data protection issues. For example, in criminal enforcement, when you're keeping lists of terrorism suspects or other, I think there's been a couple of cases in the UK especially where people are kept on lists held by police authorities, which weren't completely in accordance with data protection. So those kind of registers have not been taken into account. We're looking more at the less criminal enforcement and more general idea. So what resulted then was 27 public registers, and I mapped them on the right of this screen, because what's actually pretty interesting is to see that somewhere since the beginning of the 1990s, there's been a huge spike of this practice. So And there's also not really any sign of it slowing down, because on the left we have, I listed five registers which are currently still discussed. The two above are already part of legislation that has been finished and implemented, only the register itself doesn't exist yet. So the idea is that, well, if you have this growing practice, you know, what registers are we talking about, and what is the idea behind it, and can you sufficiently base yourself on data protection rights in the legislative process to actually justify causing this, you know, this huge growth. So, but just quickly, a little more generally on what kind of registers we're actually talking about. So, yeah, this is the most recent one. So most recently, there's been a massive growth of so-called professionals registers, which is a list of people mostly published on the internet, which with everyone who works in a certain regulated profession. So you've got lawyers, healthcare professionals, but also architects and what's called ship pilots. They're people who help navigate large ships through ports. So for some reason, the Dutch government thought it was necessary and proportionate to create a public list for everyone in that profession and put it on the internet. So going back a little bit, you have registers on the accountability of public officials, and a lot further back, which brings us back to the 19th century. You have some registers on legal certainty, as you call it. It's registers that show real estate ownership, which may inform parties whether a seller of a house actually owns the house. Or you have bankruptcy or company registers, so you know which parties you should communicate with. So, and it's actually especially this last category that have been existing since the 1800s, that there have been some issues reported in the media in the Netherlands. So for example, and it's an example I'll be coming back to later, is that you have public access to real estate ownership, which means that if there's a famous person who has a Wikipedia page with a date of birth on it, you can get the date of birth, you can get his name, you can go to the real estate register, you can fill it in, you can find him, which was also done for the Director General of the Dutch Intelligence and Security Service. So you can have people knocking on the door of some pretty sensitive people who are, you know, maybe threatened in the future by certain groups who are, you know, completely, yeah, so you get the idea. So, I mean, that issue also brings us to the next step, and that is, you know, what should the legislator actually consider when creating these registers, when deciding to publish all this data online, and you know, simply put, public disclosure is of course processing of personal data. That, I mean, it would be clear. And so the GDPR and fundamental rights laws provide all kind of requirements, but the most important here would be that the public interest of publishing all this information has to be important enough, and the measure, so the publication should be effective in the sense that it should do what the underlying purpose is. So if you're talking about the legal certainty of companies, there should actually be some sort of effect in the sense that people either actually use it or at least it has some, you know, reasonable access. And these two elements, so the importance of the interest and the effectivity, you can find that both in the GDPR and in fundamental rights laws. So in the GDPR, you have the lawful grounds of compliance with legal obligation and performance of the task carried out in public interest and exercise of official authority. And the necessity requirement there is, but the necessity requirement, that can be interpreted very strictly. So if you have a necessity to comply with a legal obligation, you could state, okay, so the legal obligation is publish all these names on the internet, so it is necessary to do that. But according to the Article 29 Working Party, this necessity requirement is also broader, as it invokes human rights issues. That invokes proportionality in the sense of the European Court of Human Rights, which also means that that the legislator will have to provide sufficient and relevant reasons for interfering with the rights of privacy and data protection, And this then essentially asks these two questions. Now, is it sufficient and is it relevant? Is it sufficiently important and is it relevant or effective for the purpose? And these two requirements, you can also find these pretty clearly in the case law of the Court of Justice of the European Union, which I've listed all the way at the end of this slide, which is that in Digital Rights Ireland, the court concluded that an interference needs to be appropriate to attain the objective. So it needs to be, in some sense, have an effect. And in the other case, which is the Schecker and Ivert case, the Marcus Volker, and that's the case about agricultural subsidies being published on the internet. The court concluded that there's an obligation to balance public interest and fundamental rights before the disclosure of personal data online. So that again, sufficiently important, sufficiently effective. So this brings us to the substantial analysis in the article, which is the question: does the Dutch legislator actually do this? Does it assess beforehand whether there's been does it assess beforehand, and does it show effectiveness in these registers? And so I have to apologize that I have to keep this short, of course, the presentation. We're talking about 27 different registers, and I only have 15 minutes. I have 5 minutes right now, so I can only provide a couple of examples. So what we've actually seen is that before the Schecker and Ivert case came out, before the agricultural subsidies case came out, there was actually very little consideration of a balance of interest in the legislative record. I mean, as the example here lists, it goes without saying that the register must be public when publishing the names of all notaries on the internet. In another case, which was the publication of ancillary jobs for judges, the legislative record mentioned online publication provides for maximum transparency. So, and that's what sort of the only thing that was mentioned about any form of any sort of bits of balance or of interest for privacy and data protection. And there have been some, there have definitely been some improvements since the case in 2010. Since 2011, 2012, there's been a sort of a standard rule that necessity and proportionality all have to be tested and mentioned in the explanatory memorandum of a rule. But still in some cases, and it's the second one you see here, that it ensures that patients, employers, and stakeholders are better informed. Therefore, it should trump privacy and data protections. What it actually says is, this is the purpose, and therefore it trumps data protection. It doesn't really seem like a real balancing act, but more of a statement A, therefore statement B. And on a more cynical note, you could also find that when it comes to the democratic accountability, the proportionality test is often a lot broader. So when public officials have to justify for themselves or justify for other politicians why there should be there should be an interference with data protection, apparently it's a lot more important than when it comes to other groups. So going on for the relevant reasons, the effectiveness of all these registers, is that what actually can be found is that the Dutch Data Protection Authority has concluded that public registrations of officials is an effective and manageable tool. It's been mentioned in one of their advices on the creation of new professionals registers. However, when we started looking for these, we could hardly find any. There was only one study, or there were actually two studies on the registration of healthcare professionals, and the only thing you could find there is that they're hardly ever used, and actually nobody knows they exist. So the outcome is therefore a little bit disappointing. That shows that the justifications, so that the balance of interest is often very poor, or has been very poor in the past, and that evidence of effectiveness is scarce. So you would expect, so there's actually a lot of lack of knowledge or public knowledge about proportionality, but this is still not led to any restraint. Like we can see, there's a huge growth, and there's what a couple of slides back you saw, there's still a lot of things to come. So based on these conclusions, how should we go forward? And at the end of the article, we had a couple of recommendations or ideas, which included, well, maybe we should look at the publication of data protection impact assessments. Data protection impact assessments are now sort of a standard procedure for public registers, but it's not being published, so we don't actually know what the results of these are. And I think more importantly is that we should look to the past and see all these registers that have been created since the 19th century and which have caused issues, as we can see the publication in the real estate register of the Director General of the Information Services. So what should we do with these registers? And I think that sort of the first step would be broader evaluation, and also in light of the new possibilities we have of combining different data sets and combining information that's already public with the information that's now being published by government entities. And I think my time is up. So that's it. Thank you.
So thank you very much. So we can take now some questions if you have about this topic before we move into the next presentation. Yes?
I have a...
Use the microphone, please, if I may.
Yeah.
I'm not 100% sure that this is a fair question for you, but you have a very strange chart, not on the page before.
Yeah.
Yeah, so from 1830 until 1920, there's very little change.
Mm-hmm.
Then from 1920 to 1985, 1990, I don't know.
Yeah.
It's pretty regular and goes up sort of at a fairly 1 or 2 per 10 years, I don't know. And then all of a sudden it goes whoosh, straight off the chart, but also quite regularly.
Mm-hmm.
Can you explain what happened at the different periods here and why it stays, why it behaves like this? Do you have any idea what's behind it?
What basically my idea is, I have to admit, I'm not entirely certain why in the 90s they suddenly decided to have this whoosh, off the chart. Because if you look at the years, it's standardized. It's 30 years, 30 years. It's standard times all the way through. But what I think happened is that we simply could. You got the beginning of the internet, and you've got privatization. But in another sense, you also had a lot more privatization of government. So you had in the 90s, you had sort of a general the new public. Sorry, I forgot the exact name of it. Sorry, but you got the new public model of a lot of governments where they privatized a lot of stuff, which also meant privatization of oversight of certain professions, which means that instead of having a government entity checking on healthcare professionals, you now have a public register which allows citizens to do it themselves.
Just a follow-up.
Yeah.
Why do you think it didn't explode? It's pretty regular from about 1980.
Mm-hmm.
It just regularly rises until now. Whereas you would expect with the arrival of the internet and sort of these developments that you would see something like what's the name of hyperbole?
Yeah. So you would expect even more.
Sort of go, completely disappear. That doesn't happen. Is there any explanation you have for that? I know this is not a fair question.
It is. But it's interesting. I mean, I agree. It is interesting to look at. I don't have an answer to that currently. No, but it's.
Well, maybe I could add a little bit. It's also speculation, but I think so. I think it's important to realize that in the Netherlands, it's a centralized country and it has already had quite a lot of registers. So if we have all the big key registers in place, there's little to gain by having more. And I think what we saw in this sort of big growth in the past few years has a lot to do with the idea that if you just put things on that line, it increases accountability. And it's sort of like using the publication as a stick to make professionals behave.
Yep.
Because most of the registers that have been newly created and put online are actually about this, about the medical profession teachers and so on.
About
So
bailiffs,
it's
about
control
Mhm.
to the public, which is seems to be much stronger these past few years.
yeah, and I think that's sort of a part of the new. Sorry.
Okay, so thank you very much. We have to move to the next presentation. Unfortunately, we are time constrained, but there might still be some time left at the end for some follow-up question on this topic. So our next speaker is Domenico Rosani. He's coming from the University of Innsbruck, and he will be presenting his research on education, children's rights, and the General Data Protection Regulation. So the floor is yours.
Thanks. Good afternoon from my side as well. My name is Domenico Rosani, and I work as research and teaching associate at the University of Innsbruck in a department dealing with Italian law, which is quite weird, I know, but we do comparative law, there is a reason. My today's topic is the implementation of children's rights in the digital environment, especially in applying the General Data Protection Regulation. A dialogue is urgently needed. Why I crossed out between education and legal sciences, I hope it will be clear until the end of my presentation. It's a one common experience that children, and with this term I mean all people under 18 years old, children widely use information and communication technologies. Internet, online services are part of their lives, and are meanwhile also essential components for the development of the child's personality. Mobile devices are increasing, connected toys are increases, devices children are in touch with all day long, connected devices are increasing, which makes the difference, the boundary between online and offline reality rather blurred, and as a consequence also it's even more difficult for parents, for educational actors to mediate the access to the internet of children. It's how some scholars have said, it's a hyper-connected childhood what children are currently experiencing. Interacting with these technologies, children give off a lot of personal data, and both the sensitivity of this data and the vulnerability of children are self-evident. Indeed, children may be at risk in the digital environment. Children may be victims of adults or peers, but, and this is somehow not so explored yet, children may be perpetrators of wrongdoings as well. Let's think at cyberbullying, at the phenomena of impersonifications and other wrongdoings. But today I would like to concentrate myself on the data protection risks. Since despite the technical ability of children to deal with these technologies, they are often not aware of their data is proceed, how marketing works and how marketing is interconnected with their lives. And this may have, or this will have serious repercussions on an educational note for sure, but this may have also serious repercussions on the level of society as well, because an unquestioning acceptance of data processing, of how marketing works, of the methods of the digital environment may lead to an unquestioning acceptance of a reduction of privacy and of an increasing of surveillance. And we have to discuss on these topics. However, the risks children may be exposed to in the digital environment shall not overshadow the extraordinary positive impact of the new technologies. Okay, you may see. So the information communication technologies allow children to gain knowledge and to gain information in a way never seen before. They allow to interact with peers and also to enjoy privacy. We have to say that as well. And third, the most interesting for today's presentation, they allow children to participate in the social discussion. They give children instruments to make their voice heard in a way never seen before. An example for this is what happened after the Florida school shooting 1 year ago, when teenagers, according to Time, have become the central organizers of one of the most powerful gun reform movements ever. And this happened mostly to the internet. A well-connected childhood may therefore have momentous positive consequences for the whole society, improving equality and improving democracy. However, the wider public discussion in Europe has approached this topic rather from a negative perspective, focusing on the risks. And also the European legal rules on data protection have been ignoring children for several years. The General Data Protection Regulation, for the first time last year, introduced rules on provisions on children, as you may see. I will soon zoom in on just a few of them, but before that, it has to be noted that the General Data Protection Regulation has not considered children when it was drafted. Children were not involved, so their opinions were not considered, and it did not rely on evidence-based advice either as regards children's data. So it was quite criticized actually among educational and legal scientists dealing with children's rights. Paradigmatic for the lack of evidence is what happened with Article 8, which provides for the consent for children to, in the case of data processing. The age requirement, now you see it is 16. The age requirement initially set by the Commission was 13, which would have corresponded to the American standard. This age requirement was raised all of a sudden until the end of the legal procedure up to 16 years. And the current provision is actually a compromise, since Article 8 provides that when an offer of information society services is made directly to a child, the child has to be 16 years old to provide consent. Under this age, the parents have to give consent or authorize it. Member states, however, may lower this age up to 13 years. But what's the rationale behind 16 years or behind 13 years? Are children mature enough at 16 or at 13? I don't know, and no explanation was provided since this rule did not rely on evidence-based advice. So member states have already taken position in this regard, as our research recently updated by the University of Ghent shows. The majority of member states have decided to go for 16, or have left 16, let's say, but there are some which have decided for 13 years or 14 years. But again, it's often not transparent how member states decided for one age or the other one. And what's more, this opening clause is leading to a jeopardization of the rules among the European Union, which actually runs against the ultimate goal of the regulation, which was the uniformation of rules among the European Union. There are a few other open issues as regards Article 8. One of them is the exception provided by Recital 38. No parental consent is needed for preventive or counseling services. Let's think at online services providing medical advice or information on sexuality for children. However, this exception is only provided in the recital, not in the actual article, which makes its status quite uncertain. And before that, the implementation of any age thresholds, it's quite tricky in the digital environment, because the methods to verify parental consent are quite weak, unless you want to extraordinarily interfere with the child's privacy, which actually I don't think it would be a good solution. As a consequence, it's likely that this rule will be generally ignored, which will have momentous negative repercussions on children, because on one hand, they are told there are some rules they have to respect. On the other hand, they know nothing will happen if they don't respect them. And again, a question. Have these educational repercussions been considered when the regulation was drafted? hard to tell. Beyond the rule on consent, the General Data Protection Regulation deals with children also in a few other provisions. As you may see, I will just concentrate myself on three of them. First, the regulation addresses the need to provide children with information adapted to their level of understanding and knowledge. It's clearly that the language commonly used to write privacy notice is a language thought for lawyers and is hardly understandable by children. Second, associations and other bodies may prepare codes of conduct which specify how the regulation has to apply in different sectors. Among others, also children are mentioned. As a concrete example, these codes of conduct may provide template information sheets for children, which are likely to be applied by industry, especially if small or medium size. They could also provide for template information sheets for parents, on which parents may rely when dealing with their children and when speaking with their children on these issues. Since draft codes have to be approved by the data protection supervisor authority, also these authorities need to be made conscious of the importance of such codes for children and be invited to have a particular closer look on the provisions regarding children. And the same applies as regards the bodies in charge of monitoring the application of these codes of conduct. And the third point is the tasks of supervisor authorities, which have to promote public awareness and, according to Article 57, activities specifically addressing children have to activities addressed specifically to children shall receive specific attention. As an example, supervisor authorities could invite business to take responsibility in this regard, but could also invite educational actors, schools, but not only schools, to provide an effective digital media literacy to children. Since, in my opinion, a crucial step to protect children in the digital environment, but also to empower them to make the best of the opportunities of the digital environment, is to provide them with an effective internet literacy from early childhood. Such commitment should involve all the different actors children are in touch with, starting with schools, which are best placed in order to reach all children, regardless of age, but regardless also of social background of their parents, in order to avoid inequalities. I know the Joint Research Center also is working with schools and educational actors in order to provide materials and information which may be used in this context. Such education initiatives should provide practical skills to children, how to detect themselves from a post, how to manage privacy settings, but it's not just about providing practical skills. They should also encourage children to critically interrogate the digital environment, the methods of the digital environment, the methods which are used by marketing, and in general to critically interrogate the role of privacy in their lives and the role of privacy in democratic societies. And here we come to the title of my presentation and to the end of my presentation as well, because protecting children and empowering children in the digital environment is hard work. Simplistic answers focusing just on some components of this topic without missing the bigger picture are likely to prove to be inefficient. And legal rules only are simplistic answers, in my opinion, since they cannot grasp the situation children face online every day. What's needed is a multidisciplinary set of solutions, and for that, different actors have to take responsibility. I initially concentrated my research on the cooperation between legal scientists, or legal practitioners and educational scientists. And this was something missing during the drafting of the regulation. But in the aftermath of the regulation, in applying the regulation, an even wider cooperation is required, which will involve, of course, legal scientists, educational scientists, but also business, also parents and families in their wider meaning, and educational actors, public authorities, and so on. And last but not least, such cooperation should also involve children in order to make sure the solutions provided meet their need and children are recognized as rights holders and have a possibility to give their opinion and to make their voice heard. Permanent clusters, therefore, is, in my opinion, the best way to bring together all these actors and make sure we are able to cope with a continuous development of technological innovation. Of course, the way how the regulation was drafted did not set an example, but now it's high time that especially academia and business give momentum to this dialogue. We shall continue, or maybe we shall start speaking to each other. And speaking also with children, which will have great repercussions on children for sure, and indirectly on the whole societies. Because on one hand, providing children with protection and empowering them to make the best of the opportunities of the digital environment will foster trust in technological innovation. And on the other hand, giving children voice and giving them instruments to make it heard will empower them to use these instruments. Or, to put in other words, it will enhance equality and it will enhance democracy in our society. Thank you so much.
Thank you very much, Domenico. So we can take now some questions about this topic. Does anyone has a question? Yes, please.
Can I speak from here, or?
Maybe better if you take the microphone or somebody.
Great to meet you.
Hi, yes. Hi, my name is Ingrid Milkaite, and I work at Ghent University together with Professor Eva Levens. And we also look into children's privacy and their personal data protection with respect to the GDPR. And thank you very much for referencing our beehive, we call it. And I just wanted to actually answer your question, not pose a new one, because you asked whether anyone has any insight into why specific decisions, age-wise, were taken. Why is it 13, 14, 15, or 16? And indeed, the European regulator did not ever explain it, unfortunately. But in our research, we noticed that actually national authorities do, sometimes, not always. Mm-hmm. And so we have a situation where national authorities sometimes refer to social media services, the age limit that they set. They refer to their previous law. So for instance, their previous data protection law, financial law, so when children can open bank accounts. And at the same time, we were also very happy to see that some countries referred to child development, their right to freedom of expression, also their protection, but in a broader sense, their inclusion in the digital society, because some authorities do stress that if children are now overprotected, meaning that they are excluded from all these digital services, then that will only have negative effects. And I think that plays nicely with your conclusion on the needs of education.
Great. Thank you so much.
Yeah, I found some interesting links between yours and my presentation, because there are other 2 points that are also related to children. Automated decision making under Article 71 cannot be done for children. It says when a child is the data subject. And also, data protection impact assessment should be always performed when there is a child. So I wanted to ask your opinion about two things. First, why they are just recitals, because for me it's like a scandal that's such a huge thing, because it's revolutionized business model. It means that whenever you have a children at stake, you have to do a DPIA, which is costly. I mean, it's expensive for companies, and at the same time you have to avoid automated decision making, which is impossible, I guess. So a recital is a weak instrument, I see. And the second point is, do you see a relationship between this childhood definition in Article 8 and all the other references? Because it's children, but what is children? It's related to the national age. It's just under 16. It's just under 13. It's just under 18, because 18 it's like a more general benchmark between vulnerability and not, autonomy and not. So some provocation, maybe.
Thank you so much for your provocations. Indeed, some provisions on children are just set into recitals, like that one of on profiling, which make their status quite uncertain. For instance, as regards profiling, the scholarship is debating also with Article 29 Working Party what it means, which consequence will have this recital on the actual implementation of the article on profiling, and there are different opinions, so it's quite a tricky question. And as regards your second question on the definition of children, indeed, if we understand children in the framework of the GDPR as people under 16 years old, we will leave without protection all children between 16 and 18 years old, because according to the United Nations Convention on the Rights of the Child, children are people under 18 years old until the age of majority is attained earlier. In the European member states, the age of majority is 18, except for Scotland, which has quite a strange situation, but generally it's 18. And the United Convention on the Rights of the Child is ratified by all member states, and therefore as is binding for them, and is binding for the European Union as well, since it's a principle of union law. It's an international obligation which binds all member states, and therefore it cannot. This a principle of union law, in my opinion, not just my opinion. And therefore, all children, and therefore the children in the framework of the GDPR have to be understood, in my opinion, as all people under 18 years old. Initially, there was a definition on children in the GDPR, the first draft, all people under 18. Then it was cancelled. No idea why. I read some articles on this issue as well, and no solutions were provided why this reference was cancelled.
Okay, thank you very much, Domenico. Unfortunately, we ran out of time, so I would like just to congratulate all of you for the presentations. Thank you very much.